Yeah. Good evening, everyone. A warm good evening to all of you. I'm delighted to welcome you all in today's webinar on mediation skills of insolvency professional. This is the 30th webinar in the series of webinars organized by IPNet, your own platform for sharing knowledge and experience of the IBC ecosystem in India. We are privileged to have Dr. S.V. Ramakrishna as our esteemed keynote speaker on the topic, a very seasoned advocate and mediator, well known in the legal circles. I'm sure he will throw enlighten the concept of mediation and skills of IP. I extend my special thanks to Sri Ashish Makija, President of IPNet, for bringing all of us together on this robust IPNet platform. The membership link is available in the chat, and we look forward to those who are yet to join IPNet as the members. IPNet has become a vibrant community for insolvency professionals across India, fostering continuous learning, collaboration, and professional growth. We are committed to supporting IPs through expert led learning initiatives like webinars and study groups, practical guidance on IBC related challenges, and we have a dedicated member portal offering comprehensive resources. For those who are already part of IPNet, we thank you for your support. And for others, I encourage you to join this dynamic and ever evolving network membership detail. The membership details are available in the chat. Thank you all for being here. Let's make this session insightful and rewarding. Now I request Namrata ji to play the IPNet website video and also introduction of IPNet video.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Yeah, Suhasini, please take it forward.
Yeah, thank you, Namrata ji. Now I request Ms. Pavitra Vyas, insolvency professional and practicing company secretary from Belgaum, as our speaker.
Good evening, everyone. I welcome you all on behalf of IPNet. Dr. S.V. Ramakrishna is a multidisciplinary professional from a development bank from 1977 to 2003 and took a voluntary retirement as Assistant General Manager of IFCI Limited, New Delhi. Now, after 2003 onwards, he has practiced corporate law in courts, DRTs, DRATs, NCLT, NCLAT, civil and criminal courts, and also arbitration matter. He is founder of SVRK Law Associates, a multidiscipline law firm with about 20 years of experience. Dr. Ramakrishna is a doctorate in law, holding PhD in law, corporate governance, in company law from India's one of the premier national law school, Nalsar University of Law. His research topic is corporate governance as a turnaround strategy, a study of listed companies in Andhra Pradesh. Dr. Ramakrishna is a postgraduate in commerce. He is also a CAIIB Mumbai, fellow of Institute of Company Secretaries of India. He is also LNM. Besides, he holds 3 postgraduate diplomas in HR, marketing, and sales management, and business administration from different universities and institute of repute in India. Dr. Ramakrishna is a certified mediator, having undergone 40 plus hours of training, passed 20 examinations before, certified by the National Legal Service Authority. MCPC of Supreme Court of India conducted the program. Dr. Ramakrishna had board level corporate experience as IFCI's nominee director in some of the reputed companies, including Inadu Group of Ramoji, as independent director in groups like L&T, Nagarjuna, Brit Country, etc., and also acted as government director appointed by erstwhile Company Law Board. Dr. Ramakrishna is a frequent visiting faculty, guest faculty in corporate law and corporate governance in leading universities and institutions of national and international repute, including Administrative Staff College of India, Usmania University, Lalsar University of Law, National Law of University, Delhi. Addressed NCLT 2019 batch, Judicial and Technical Members, Institute of Directorate. Dr. Ramakrishna is successfully conducted and gave award as a sole arbitrator in a high-profile case and also appeared in number of arbitration matters apart from teaching the subject to professionals. He edited some chapters of Handbook on Arbitration published by ICSI, Center of Excellence, Hyderabad. He is also a panel advocate of SBI, Allahabad Bank, Corporation Bank, Union Bank of India, SIDBI, IFCI Ventures, Airport Authority of India. Dr. Radhakrishna is life member and one of the founder executive committee member of NCLT Hyderabad Bar Councils. Dr. Radhakrishna's hobbies includes writing poetry and released his collection of poetry and entitled Voyage of Thoughts. We welcome you, sir.
Twice you, thank you, ma'am. Twice you repeated Radhakrishna, I am Ramakrishna.
Ramakrishna, sir.
Thank you very much. So, should I start my discussion?
Yes, sir. We can.
Okay. So, the challenge to me is that you want to name a baby which is yet to born.
But it's already in the womb, sir. So
That's why. So,
yeah.
some Namakaran will do. For IBBI has come out with a concept paper. I think more than 200 pages, you must be aware of that. Companies Act 2013 has a provision for mediation. And though we are in 2025, government has not framed the rules. So generally people are referring the matters to arbitration and conciliation. Now the conciliation has subsumed into Mediation Act of 2023. In 2023, the Mediation Act came into operation. And if you permit me, I'll show some slides. Is it there?
Yes, sir.
Okay. There is a famous saying, law must be stable, but not stand still. It must change with time. It should be stable, otherwise society will be upset. But it should change with time. So time is coming for mediation, even in not only civil disputes. The IBC is not for disputes. But government thought at least one portion, that is section 9 matters, can come under the dispute. Even the point is, if there is a dispute, it cannot be admitted into IBC at all. You agree all? Pre-existing disputes are outside the purview of IBC. But why IBPI thought it fit to bring into the fold section 9 matters, where some possibility is there to reduce the burden on the companies and the tribunals, adjudicating authorities, and also to stave off the serious consequences of admission into IBC and a loss of control of the directors. And we know how the things are happening. So ultimately it upsets the entire process. So the presumption is that the company has gone into virtually beyond repair. That's why we want somebody to take over this company. But in case of operational creators who are material suppliers or service providers, there could be a possible solution. An operational creator does not want the company should be closed, honestly, because his interest is at the greatest stake. He gets nothing. If it goes into liquidation, being an operational creator, standing in the last row of the claimants, they get virtually nothing. But if the company's management and the operational creators come together, solve the problem, and that should be mediated by a qualified mediator like us, IPs, that all IPs can be mediators tomorrow. There is no bar in appointment of them. But if somebody is qualified, maybe small preference may be given to them in case. But we should know some techniques, tools, and certain how you handle we should come out of the litigant mode and come with something which is envisaged under the mediation, which is entirely different from adjudication. Let me give you a caveat. In the adjudication, it is heartless, based on facts and what is right, whether as per law, an action has been right or wrong. And they don't bother about our emotions. In fact, every judge says, don't carry your client's emotions into the court hall. We decide on merits only. But mediation is slightly opposite to that. It is the party-centric. The parties will decide how to solve their own problems. No force will be on them to settle the matter. But the greatest challenge to a mediator, proper mediator, is that he has to make aware both the parties, a process to be followed, a lot of patience and understanding of the psychology of the parties, facts of the law, and provisions of the law, facts of the case. He should have a broader understanding, but in a subtle way, like a shepherd bringing the sheep together. He has to be a father-like figure. He has to bring sense of understanding of the issues before the parties, show them what is the future would be, what is the most likely adverse thing, or most likely favorable thing, or anything can happen. We call it as what now, but now, malat now, something like that. We'll discuss that. I have time up to 4:15. What is it? Up to 5 o'clock, I think. What is the time available to me?
Sir, you can carry on till 5:15, sir. Then we'll have question answer sessions.
That's fine. So now I'll move one by one.
Sir, before we start, how do you want to take the questions as the session goes on?
In the last
After
we'll
the
take it.
session.
In the last, the better is because most of the questions might have been answered
Answer.
during
That's
the
right.
discussion stage.
Okay.
So
I
if
request all the
anybody-
participants to keep posting your questions.
Participant can note their questions, and to the best of my ability, we'll discuss.
Sure, sir. Thank you.
Now, mediation is not today's concept. It was there in the India's ethos, and India is had a robust mediation system in the olden days. Okay, it's an age old. All of you know it, but just I give only touch upon this necessity for a peaceful social life. We want to solve the problems. Even today, the other day, in there is an attack in Kashmir on the tourists. There is a immediate passions rose up. Now they have gone to United Nations Security Council today only. Just half an hour back, I heard the news. They want to pacify both the countries who are nuclear weapon countries, and in the name of the because of this particular condition, we should not be guided or controlled by passions. So think coolly like that. What does it mean? It's also a sort of mediation. United Nations organization is meant for that only. So we want to let the passions or feelings be burst out. It is unlike a court system. In a mediation, we allow the emotions to come out. If you hear patiently as a mediator and allow the clients to or litigants to ventilate their feelings, 50% problem will be solved because there is nobody to listen to them. So it boils inside. Once the particularly family matters, okay, once we allow the parties to express their emotions, the reason will prevail later on. Otherwise, in an emotional stage, the decision making goes wrong. Thinking will be obstructed by what do you call a screen, smoke screen like, and they can't see the reality as it is. This is typical mediation I'm talking about. Okay. Now, friends, India has a robust mediation system. I already told you. There is a mediation reference in the Dharma Shastras and epics like Mahabharata and Ramayana. And Vedic literature talks about divine wisdom, that is Dharma. The god of fire considered to be a mediator in Rig Veda. Yajnavalkya, he talks about trade, commerce to be conducted on principles of justice and equity. So India is one of the earliest trendsetters in mediation, but even in the Maurya and other times, we have different platforms created by society. We call them as Kula, Shreni, Paga, caste-based community elders, sometimes trade guilds, Shrenis for artisans, okay, Panchayats, of course, 5 wise men, and trade guilds and associations. Even today, we have the chambers of commerce, etc. They are also mediating. Buddhism and Islamic period influenced the 12th century Sharia, Mughal era, etc. in some form or the other. Even when the Britishers came to India between 1753 to 1947, the traditional mediation in India took some beating. They established courts, formal courts, Britishers, during this period, replacing local indigenous dispute resolution process. So they brought into a system, a legal system, which was practiced by British in their own domains. The conflict between British values of a clear-cut decisions, that is what typical legal system. Indian values of compromise. Compromise is the first method of solution we prefer in India. Even if some road accident took place or somebody rashly gone and hit somebody, though initially they will be reprimanded, they will pacify and send both of them. Over 200 years of British rule, it sidelined the traditional mediation techniques in India. And the British grew its own courts of law system, eventually becoming into India's legal system. That's what we are following even today. Now, coming to the legal framework of mediation, arbitration, and all that, the 1996 Act replaced the earlier Act. Industrial Disputes Act of 1947, one of the oldest labor laws, it talked about mediation and conciliation. There are mediation officers to solve the industrial disputes. And in 1987, a formal act was enacted, which is called Legal Services Authorities Act, NALSA we call it. And NALSA conducted this Mediation and Conciliation Project Committee, established under the supervision of Supreme Court, and Chief Justice of India as a chief patron. So I have undergone this training and got the certificate from them. In 1995 and 96, Supreme Court undertook a joint study with Institute for Study and Development of Legal Systems to address delays in litigation and suggested amendments to CPC. The first thing they did is Civil Procedure Code was amended to provide a mediation process. Section 89 of Civil Procedure Code was introduced in 1st July 2002, and under which settlement of disputes outside the court are permitted, rather preferred and encouraged. And thereafter, our Companies Act, our own, Section 442 of the Companies Act 2013 provides for mediation. So central government to maintain mediation panel for cases before them, NCLT or NCLET also. So any opportunity coming to our friends, get qualified as a mediator, because that is going to happen very soon. And companies mediation and conciliation rules 2016 regulate appointment of mediators, procedure, ethics, etc., but not effective till date. Now, IBC is talking about Section 9, I already told you. Even under this Mediation Act of 2023, number of other laws also amended, similar to our IBC, where providing for mediation under those specific acts, including RERA, Section 32G, it provides conciliation now, Consumer Protection Act, and so many other acts. The essence and substance of this is mediation efforts are recognized in a legislative, judicial, and social context, and continually reaffirm mediation importance for fostering peaceful resolutions to disputes. Ultimately, we want peace. At its core, mediation empowers individuals to actively seek peaceful solutions. Please note the point. It empowers the individuals, not the judges, not even the mediator, driving its continuous rediscovery and adaptation from time to time. How you solve a problem? Ultimately, solution is essential. Broadly, my dear friends, the essentials of mediation is, it is an assisted negotiation. That means you are assisting the parties to negotiate or bargain in a flexible process away from the judicial process. And mediator takes parties closer to a solution or a termination of the problem. Application of tools and techniques to inspire and assist parties towards a settlement. So this is a major task of mediator, is that you have to apply various tools and techniques, including psychological techniques, to inspire and also assist the parties towards settlement, not towards litigation. You're being a mediator, you're only facilitator and not an advocate. We should get rid of the thinking of like an advocate or a judge, or not even arbitrator. Arbitrator is replacing the judge, or a spokesman of any party. You should not take sides also. These are very, very important points in litigation. Otherwise, if anything missing, mediation fails. He is in command of the entire process of mediation, but he is not controller. There is a difference. He should have empathetic listening is the essential quality of a mediator. First, you should be able to listen properly with empathy. Empathy means understanding the pain and pain of the party who is speaking. So emotions play important role, unlike in a litigation. I already told you this. In mediation room, emotions are vulnerable inputs. So the mediator, in fact, I'm handling three mediations right now, live. I'm appointed by High Court of Telangana. So one is a criminal, other one is a writ petition based. Okay, a big, I think world's top, one of the top most software company. I don't want to name it. And one typical wife and husband problem also. Okay, domestic violence, this, that, whatnot. So I have a range of cases, really interesting, and we are doing our best. So mediation room, we should allow the emotions to burst sometimes, but we should not allow them to beat each other. Okay. And they are the invaluable inputs for the mediator. He has to note down those points. And free expression should be encouraged to heal old scars. Actually, what happens? The perception of a problem ingrained in the mind, based on a deeply hurt emotion or a feeling, it will remain for a long time. In one case, what happened? The daughter-in-law, educated in London, and son, educated in America, married in Hyderabad. Okay. And father-in-law wanted daughter-in-law to touch her feet. That is a trigger point. It went up to divorce. Okay. And in a fit of anger, the father-in-law threw a chair at the grandson, her son. She took it as a greatest this thing and filed domestic violence, this, that, whatnot. Today, the grandfather wants, I want to enjoy the company of my grandson. But she's not allowing because of the deep scar she suffered. So these are the emotions. As a mediator, we have to really understand, listen like a father, mother, okay, and bring them. We have to tell them what is the future. It is a futuristic solution, not away from the past. But nobody listens unless you have, as a mediator, unless we have our sometimes our personality also works well. Patient hearing, patient listening, and giving solutions, suggestions for solution. We should not, as a mediator, should not give any solution. Please note this point. We are only facilitator. Okay. So this next, the parties understand, and that they are also other side also a human being. Sometimes we will have a single session, caucus we call it. Then we have a joint session, and again single session, come back. So you should not lose the patience at all. But whether it works in a typical section 9 or not, we have to see. In section 9, the medicine will be slightly different because the commercial interest is the dominating aspect in this kind of section 9 matters. So there's some give and take, then showing them what is a lengthy litigation, how it helps or how it damages. And once a company goes out of your hand, everybody is a sufferer. Okay. So somewhat, some give and take, a lot of things are there. Law alone cannot resolve problems. This is age-old and universally accepted principle that law alone cannot solve the problems unless we live together in a give and take old system like live and let live, like that. Law provides a solution to protect individual rights, and mediation brings both the parties for amicable settlement of their own disputes. So they are the authors of their own settlement. This is the essential point, my dear friends. In a mediation, the parties are the authors of their own settlement agreement. Whereas in a judicial process, court is the author of the order or judgment. And we have to show them what is the best alternative. If you don't want to settle the negotiation, if you don't want to arrive at a negotiated agreement during the mediation, what would be the best alternative it can happen? Who will be the sufferer, who will be the gainer, or what happens? Similarly, what is the worst alternative if you don't come for a negotiated agreement? And this, you may not be knowing what is best, what is worst, but can be a most likely alternative. That's what we call Malatna. Most likely alternative to negotiated agreement. This we have to explain them. One more also there. Now, some typical advantages are there. All of you know it. This is a pre-litigation step. Normally, courts today, under the Mediation Act of 2023, in September it became Act, they are duty bound to refer the civil matters other than Schedule 1 cases. I will discuss that also, to the mediation. Then mediation is voluntary participation of litigants. If they don't want, sorry sir, we don't want any mediation this evening, we'll go to court only. You decide. Then you cannot do anything. It's not compulsion. A chance is given to the parties to come to a settlement. Then mediator will be appointed. And remember, mediator should not expect any fees and all those things. If court gives, fine. Otherwise, you cannot expect anything. There is no schedule like Arbitration Act. Mediator role is assisting a settlement ending the litigation. For that, he has to explore innovative. He has to be highly creative also. Out of box thinking in assisting some of the litigants. And we say that you want this, I want this. Suppose take Section 9 matter. Somebody is producing a brand named garments. And somebody is producing raw cloth, supplying to those branding company. Okay. And there is a dispute. And they want some problem happen. If they divide, what happens? If they think that the world is a larger one, and a particular brand is operated in a particular state, 1 or 2 states, manufactured in a different state of the cloth, then if they come together and promote a joint venture company and reach other states also, both will be the beneficiaries. This is out of box thinking. Instead of typically thinking what is my share, what is my this thing, we have to increase the pie and share a bigger pie, bigger share in the pie. So this is a very creative, rather mediator has been given this kind of privilege to encourage the parties to come to a out-of-box thinking solutions. For that, the mediator himself first, he should unlearn, learn, and relearn various dimensions of each case and its nitty-gritties. So learning is a process, all of us know. What is learning? Learning is the process of accumulation of knowledge and information, etc. That's not enough. New understanding, new knowledge, and new skills, etc., he has to adopt or internalize. He should have the ability to learn the process, how it goes. Tendency is attachment to the known and reject the unknown. That is a status quo, we call it. Psychologically, we are wedded to what is safety, what is known. Unknown always we avoid. So a mediator should unlearn. That means unlearn is a process knowing new thing apart from the old thing. So giving way to new thing is an unlearning process. Then relearning. That means fresh thoughts. And finally, bring the parties with this kind of understanding of the case, bring them together, go one step above their understanding, and show them the path. Well, we have wonderful Supreme Court judgments. You can note down these, friends, and you can see the judgment for yourself. Salem Advocates Bar Association case of 2005. Then Afghans Infrastructure Limited versus Cherian Varki Construction. This is a very important judgment. Case Srinivasarao versus Deepa also, family courts matter, that is. But in all these 3 cases, Supreme Court laid down certain guidelines on importance of mediation and what is to be mediated, what not to be mediated, how to be mediated, and all those things. Because of the paucity of time, maybe I may meet you at a later stage, then I can discuss in depth this case laws. Now we have two acts. One is Legal Services Authority Act, and other one is Mediation Act of 2023. The Legal Services Authority, it is an act to constitute Legal Services Authority to provide free and compulsory legal services to the weaker sections. That's why Lok Adalats, these are all organized at a free of cost and low cost and settle the matters. And sometimes we have state Lok Adalat and national Lok Adalats also. So under the service of legal services authorities of the state level, district level, national level, they are organizing. Now our act, Mediation Act, it has a beautiful preamble. President gave assent on 14th September 2023 to this act, but it is not fully operational, only bits and parts coming, and maybe 6 months down the line, it should be fully operational. The preamble always gives why this act has been enacted. It is an act to promote and facilitate mediation, especially institutional mediation. That's why they are giving trainings institution-wise, and they are also helping to come to a institution. That may be the reason why our Companies Act has not really came into operation in mediation matters. That is coming. And for what? For resolution of disputes, commercial or otherwise. Otherwise means what? Family. One more great point is there, I'll come to that. Enforce mediated settlements. Once mediated settlement is arrived at, it is as good as a decree. It has to be enforced, and there cannot be any appeal on that. Then, or otherwise enforce mediated settlements, provide for a body for registration of mediators. So, like our Bar Council of India, Medical Council of India, our IBBI, Mediation Council of India is coming under this act. So, if we are qualified, like doctors, lawyers, and IPs, we can all be registering there. So, naturally, it will be a great assistance to our profession, and also we will be assisting the system through our mediation knowledge. Okay, a body for registration, encourage community mediation. This is a wonderful act, a wonderful word. For the first time, we are talking about community mediation. Suppose Hindu, Muslim, Christian, or some communities within the communities, even those can be referred to mediation today under this law. No, many people do not know this. Community mediation, two castes, two groups. What is happening in Manipur? Community mediation is badly needed there. So we bring two community leaders, use all our techniques and tools of mediation, and you show them what is the future of your children, your own future, your grandchildren's future. What is alternative? That's why what now, but now, malat now. These are the things we have to really. Actually, community mediation should have already started. It is late because many problems of the society can be solved through this act. And there also we are registered mediators. We have a rule. So let us be the first early birds. Okay. Then make online mediation also acceptable today, and cost-effective process, that is online. Okay. And of course, connected matters. This act has been enacted. It's a very small act of 65 sections, and some schedules are there. Like anything, short title, application definitions, mediation, what is mediators, mediation proceedings, enforcement of mediated settlements, online mediation, Mediation Council of India, section 31 to 39, Mediation Council of India, and mediation service providers like our IPs and all that, mediation institutes, then community mediation, 43 and 44, two sections devoted to that. And disputes are miscellaneous, of course. Then schedules are there. In the first schedule, very important schedule is disputes are matters not fit for mediation. You cannot send every dispute to the mediation. I'll discuss that also. And other schedules are nothing but amendments of the different acts. The Law Ministry on 9th October, they have brought into operation some of the sections on 9th October, and still some more to come. The first schedule says, what are the disputes cannot be, which are the matters not fit for mediation. It's a negative schedule in the sense, these matters cannot be referred to mediation. The first one is disputes which by virtue of any law for the time being in force may not be submitted for mediation. If any dispute is in such a nature, law provides that it cannot be referred to mediation, then it cannot be. Then disputes relating to claims against minors, deities like Ram Mandir and all that, persons with intellectual disabilities. Okay. And paragraph 2 of schedule 2, schedule and a person with a disability having so and so, so and so, so and so. And another act is there, mental health care matters, persons of unsound mind, in relation to whom proceedings are to be conducted under CPC, and suits for a declaration of title against government. Suit for a declaration of a title against government, like Waqf now is coming. That's one problem is there. They are not fit for mediation. Declaring having effect of a right in rem. Now, friends, we are all company secretaries and professionals. Right in rem and right in personam, there are two doctrines. Right in rem means a remedy in general. Remedy in general. That means not against any individuals. Right in personam is individual rights. Like prevention of operational mismanagement of a company is a right in rem, not in personam. If 10% of the shareholders file a petition under 241, the remedy is available to all the 100%. It's a representative in nature and derivative right as a shareholder. Now, another thing is disputes involving prosecution of criminal offenses. If a criminal offense is there, that cannot be mediated, because a crime not only against the victim, crime is considered to be a crime against the whole society. And the duty of the state government is to prevent such crimes by giving exemplary punishment to the perpetrators of the crime. In a criminal justice system, the victim never gets justice. It is only a retributive justice, and the person who committed will be punished. That does not mean that the victim will come back to life if it is a murder case. Damage already been done. Other cases. Okay. And another thing is complaints or proceedings initiated before any statutory authority or body in relation to registration, discipline, misconduct of any practitioner, professional misconducts. Professional misconduct of a lawyer or anybody cannot be mediated. It's a punishable offense. And other registered professionals, so you recognize, you see yourself who is the other registered professionals. Okay. Such a legal practitioner, medical practitioner, dentist, architect, chartered accountant are in relation to any other profession of whatever description, which is regulated under any law for the time being in force. Though our professional conduct or misconduct is regulated by our own act, like Companies Act or Bar the Advocates Act, whatever it is. That cannot be mediated by a mediator. Otherwise, system will be diluted. Another thing is disputes which have the effect on rights of third party. Suppose you and I have a dispute. We went to a mediator and settled it. But actually, it affects a third party who is not before this. That cannot be mediated. Okay.
Sir, change the slide, sir.
Yes. So any proceedings in relation to any subject matter falling within any enactment over which the tribunal constituted under the National Green Tribunal has jurisdiction. Similarly, NGT matters. Okay. They are also not amenable for mediation. So any dispute relating to levy, collection, penalties, etc., of taxes, because government does not want to lose them. Any investigation inquiry pending under the Competition Act, that is also out of the mediation, because there is a specific authority to adjudicate that dispute, having its own impact. Then you have proceedings before appropriate commissions, like Electricity Regulatory Commission, Natural Gas Regulatory, then regulators, even IBBI for that matter, SEBI, okay. And last but one is land acquisition and determination of compensation under the land acquisition laws. So Land Acquisition Act is there, that there is a tribunal, separate tribunals are there. It cannot be mediated. It should be specific. And tomorrow, government can add anything in this. There is an enabling provision, they kept it of themselves. Now, friends, IPPI, of course, all of you know it. It came out with a voluntary mediation mechanism for a proposal. Okay. It is proposing to voluntary mediation for Section 9 matters, and IIPI also involved in that. So voluntary mediation, what they say, operational creditors will have the option to attempt mediation before initiating the insolvency proceedings. See, operational creditors are given the chance, not the corporate debtor. Then focus on disputes. The mediation framework will focus on resolving dispute related to matters like contractual disagreements, quality issues, underpayments, claims, set off the claims, and all that. So virtually they are converting an IBC matter into a civil dispute. Section 9, they have seen, our framers of law have observed, and also IBBI team that over their experience is that most of the Section 9 matters are disputes, can be solved through mediation rather than burdening the adjudicating authorities with all sundry cases. That must be the intention. And potential benefits are, IBBI expects, it could lead to faster recoveries for creditors also by resolving disputes amicably and avoiding lengthy litigation. That is a standard. So am I clear to you so far?
Yes, sir.
Okay. Now we'll see what are the processes. Little bit. In mediation, there are certain stages. How you start with it. First, separate session, we call it, or a caucus. You listen to each party patiently, and you have to welcome them like a. You should be like a friend, philosopher, guide to both the parties, but without giving any attachment to anyone. Then you should give opening remarks saying that I am so and so. You can call me like this, and all those things. Okay. Then he summarizes the entire issue. What is the agenda before him? Then he will seek clarifications. He will give options. Actually, options is the essence of mediation. Not one solution. You explore second solution, third solution, even 100 solutions. You can encourage them. Please come with your solution. What is the alternative? What is the alternative solution? Then ask them to list out as many as possible. And when you net out both sides, then you will come to know some common agreeable or most likely agreeable points. On that, you should allow them to work and give some encouragement. And finally, we have to record the decision taken is like this. Okay. Of course, the purpose of each stage is that to assess suitability and safety, to prepare, including the analyzing the diagnosis. First, you should be like a doctor. You should analyze what are the cause of the problem. Some are confidential, so you can have one-to-one. Thereafter, you have to have one-to-one discussion with the other party also, particularly in family matters. Then there will be highly sensitive. They don't want to share with others, not in the presence of others. But if you gain confidence, they will share with you. and you should not share with others. Confidence is the highest degree expected in a mediation matters. Confidential, party-driven, and futuristic solutions. Then, of course, Wolski, he has given a role of a lawyer in mediation, like professionals, advise clients of the law that applies to them, provide legal information, maximizes, then encourage client to look at own and broader interests, then generate options to meet broader interests, evaluate options from point of view of the client, evaluate the merits of the case, what could happen. That's why no, what now, but now, and malat now. Then project likely results in an adversarial setting. Adversarial is the litigation typical. Then assess the likely litigated outcome. Suppose if you keep on litigating, what happens? You may win now. Then the other party will go for appeal. And again, second appeal. How long? Precious time is lost. Meanwhile, opportunity is gone. Your money, costs. So all these things we have to bring to their sense. And finally, promote informed consent, then guide towards possible responsible decision making. They are answerable to their own decisions. So like that. So friends, here I would like to take a small break, or rather pause. Almost I'm closing the discussion. Now, if you have any questions, I can keep it open for 10-15 minutes. Then we'll close the discussion. I'm very clear that because the IBBI has not come with a clear-cut policy or the guidelines, and it is not a law today. Only Mediation Act 2023 is enacted, came into operation, but the guidelines yet to come. And institutionalized mechanism should be set in place. Companies Act also provides some provisions. So they are all working in tandem. Maybe 6 months down the line, we expect a proper mechanism in place, and we will gear up towards that mechanism. So some of the thoughts and the experiences I got from my training, I tried to share with you. Within the short span of time, I cannot, because the 40+ hours of training, I cannot tell in 50 minutes. Okay. So you can appreciate my impediments. But I try to give you an overview of the entire matter.
Sure, sir. Sir,
Yeah,
thank you so much, sir.
Yes.
Yeah, sir, before we get into the technicalities of the Mediation Act itself, there are certain questions from the professionals as to how do we become mediators and which professionals are eligible to become mediators.
Yeah. You can access the nalsa.org, nic.org, NALSA, NALSA, GOVIN. You can use that. They will be announcing the schedules from this period we are taking. But how they, in fact, in my case, they have selected only 32 advocates throughout the country. 25 only qualified. I am one of those. Okay. So it is, sometimes they announce it. Mine is a pilot project. I am a member of the first pilot project of the MCPC, Supreme Court. Some of the state legal authorities, I think our cost accountants institute also, I think Mr. Krishnamohan is underwent that training, our friend. Okay. So they will be they also organize something. So anywhere you can register and undergo minimum 40 hours training is a must. Thereafter, they will give you some certificate, and you have to register with the NALSA state level legal services authority. I got from Supreme Court NALSA, they sent a letter to state legal services authority, and they have invited me, giving the cases. It happens like that. It can be civil courts also. And if you are registered with civil courts, the district legal services authority, you will get more cases. And after 20 cases you handle, and of which minimum 50% should be successful mediations, then you will be eligible for Supreme Court accreditation. So there are good opportunities. Please explore them. how to enroll in the mediation programs conducted by NALSA and others, you will get it.
Sir, is
And
there a pre-qualification to do this program, sir? I mean, you have to be a CA lawyer or a...
I think, I don't know how they selected. In fact, one of my friend in the Supreme Court, he's a senior advocate designated. He one day before he suggested that, Ramakrishna, there is an advertisement, tomorrow is the last date. And that night I applied. And his wife also applied. She is also advocate in Chennai. And he is in Delhi, mostly, Supreme Court. We three applied. I and his wife got, he could not get. And he is 32 years senior advocate there. So how they selected, I don't know.
IICA is also conducting.
Pardon? Yes, yes.
Indian Institute of Corporate Affairs also is conducting a program.
Yes.
On
So
mediation.
any institution of national repute, please enroll.
And IPA of ICMAI also is conducting.
Yes.
Eligibility is mostly like any advocate or any chartered accountant or any professional is eligible to become a mediator.
That too under different organization. Suppose Supreme Court may have its own, and ICWA has its own. You should be a member of the institute, something like that. Okay, please explore that. I'm not aware of those things.
Sure, sir. Thank you. Thank you for
Arora
that,
sir, you have something?
Hello.
Sorry.
Yes, Arora ji.
Yes, sir. Sir, actually, I am a senior technical consultant basically.
Okay.
I have become insolvency professional also a year back only.
Okay.
And of course, my age is nearing 70, so I may not be able to work as an IP. But Indian Council of Arbitrators, I am a member since 2004 there.
Okay.
So I'm a live member with them, and then I do some small work for the insurance survey. The mediation or the
insurance is a big area. Insurance is a big area.
So what shall I do? I mean, to get I have to get 40 hours training or registered with somewhere.
Yeah, 40 is a minimum requirement. Yes.
Okay. So which are the institutions? If somebody can who knows in the group can elaborate and send in the group, so that we can seek the
yes, I think the moderator or the organizer can help you.
Yes, sir. Yes, sir. We'll do that.
And
Anuji, you can help our friend.
Sure.
If you can help by giving the number or email ID number.
No, Arora ji, Arora ji, you are telling you are nearing 70.
Yes, I'm 69 years.
That is an advantage to you. I am more than 70.
Nice, sir. Nice. But you don't look like that.
Don't think you are old. We are not old. We are seniors.
Yes, seniors. That's right, sir.
Yes.
So that these industries have got the vast experience, sir. So that technical side is very good for me.
You might have acted as an arbitrator in some of the cases.
Small cases only, sir. Even now, High Court Chhattisgarh, they have asked me to mediate for one of the cases. They have given a panel of 3. My name is included there.
Good.
It is a big case, of course. Maybe in crores, you can say. So if I get a chance, I'll do that, sir. In near future.
Please do it, sir. Chances will come, sir. System needs us. But the only thing is, we should be known to the system.
Right, sir. So actually, for me, being an engineering graduate, I did, of course, PhD
In fact, I appeared before an arbitrator who is an engineer in Airports Authority of India case. I'm advocate for Airport Authority in a mediation matter. He gave a beautiful judgment.
Right, sir. Right.
So he's a technical engineer, he is, but he gave
Right, sir. Your guidance may be required, sir. You may send your email ID and phone number so that
our institute knows, our IPA people knows. We are always we are all one team wherever we are.
Right, sir. Right.
Thank you very much. System. I believe that.
Thank you very much.
Yes.
Sir, you may close the presentation, sir, so that we can have on the audience.
Yeah, I'll share it. Can I send it to you right now?
You can post it in the chat also, sir, or you can send it to me. I'll post it, sir.
I'll send it to you through WhatsApp, and you share with others.
Okay. Sir, you may close the PPT now, sir.
That's fine. 1 second.
In the messages, I typed the organizations which are giving the training and for mediation.
Thank you, Krishnamurthy sir.
You can see
Thank you
the
for that.
chart box. You can see the chart box.
Yeah. So, sir, my
Okay.
next question is, sir, the very reason for introduction of mediation is it to because the tribunals are overburdened with this and there is pendency
No,
of cases?
if you pick up the Bear Act of 2013, 2023, can I read out statement of objects and reasons given?
Yes, sir.
Yes,
The
please.
statement of objects given by the minister when he introduced the bill. That is the reason why he has introduced it. Can I read out?
Yes, sir.
An effective dispute resolution process has a significant impact on the economy and doing business in the country, thereby promoting ease of living for citizens, access to justice and rule of law. This is the primary objective. The rapidly changing society and progress in various areas not limited to economic, industrial or financial sectors demand commensurate expeditious settlement of dispute between the parties, which at present is time consuming. At present it is time consuming. That is the reason why to reduce the times in litigation. I could not hear.
Yeah. Sir, Rajiv sir, आप mute कर सकते हो?
Yeah, sure.
Yes, sir.
Yeah. And another object is mediation results in an amicable solution of disputes in civil, commercial, family, matrimonial matters and fosters collaborative approach, reduces the burden on the courts and preserves relationships amongst disputants. This is very important. In an adversarial litigation, one will succeed, other will not succeed. It won't promote harmony between them. That difference always remains. But in a mediation, party-driven settlement, futuristic in nature, so both will be happy. This is
This is a win-win situation for both of them.
Yes, win-win situation, exactly.
Sir,
And also,
yes. Go ahead, sir.
That's why, therefore, bringing a comprehensive mediation law and providing for online mediation may serve the interest of all stakeholders as effective alternative mechanism for resolving disputes. So it is an alternative mechanism for resolving typical disputes and saving the time and promoting the relationships between the parties. Suppose an operational creator had a problem with the corporate data. If the mediation they solve, they will further go. They continue the relationship. They continue to supply the goods and they may get more benefit. Who knows, tomorrow they may join together and promote one special purpose vehicle for a enhanced business. These things are possible. Yes,
Sir, having said so that, this is a voluntary action. It is not compulsory or it is not mandatory that the IP or the Section 9 application has to be pre-mediated.
Yes.
Correct. It is a voluntary thing. Secondly,
Yes.
sir.
And operational creator has a choice. First choice is operational creator because he is filing the case.
Yes, sir. So if by giving the demand notice or before serving the demand notice, should the mediation start or is it after that, sir?
Unless it is numbered, it cannot be institutionalized mediation.
So you mean to say first we have to serve the demand notice?
No, you come to the Section 9 filing petition with 2,500 rupees.
Okay.
Then court will give a number.
Okay.
That what you call CP bracket IB OC, then 9 HDB, something like that. So that 9 will come now.
Yes,
then
sir.
In the first hearing, the operational creator can say that, Lordship, kindly refer the matter to mediation. We want an amicable solution. But many people, they use it as a lever or a blackmail mechanism. Once it is admitted, all the directors will go to the roads. So we will have some edge and all that. So with that fear psychosis, they will come for settlement. But that has not helped much. Initially, our experience is that initially, no OC interested in closing the company. They want
Correct.
money only, but using
Correct.
this as a mechanism to recover.
Recovery mechanism.
Yes. But though it is a lofty word, resolution of insolvency and all that, okay, which operation creator really interested in resolution of company's problem?
Absolutely.
Wants to resolve his own problem.
Okay. Sir, but since the decision of a mediated processes is not binding.
No, please repeat, because I
So
find a fault in that. In your
No, sir, if there is a premeditated decision which is taken.
No, again you are using one word, decision.
Decision, yes, sir.
Decision. Mediator cannot decide.
If there is not mediator, sir, by both the parties, if they have
settlement.
arrived at a decision,
Then it is settlement.
It's a settlement. Okay.
Yes.
If there is a settlement, is it that, suppose today I have arrived at settlement, but tomorrow I change my mind. So can I still go to?
No, you are not entitled to come back or violate. It is more binding than a decree.
So is it enforceable under law, sir?
Yes.
Or once the decision, once the settlement is done?
Further. No, you cannot litigate further in any manner.
Okay, for the same cause of action.
Same cause of action, matter ends.
Okay, so it might amount to res judicata.
We have
yeah, not only res judicata. Res judicata, if you allow the other case. It's once for all closed, that's all. Because both parties voluntarily signed the mediation settlement agreement. And it's binding on both. And they were given ample chances to discuss.
And sir, like we have NCLAT or Supreme Court for the appeal, there is some provision must be there for appeal here also, if there is something done.
Yes, sir. So appeal against an impugned order.
Impugned order, okay.
What is that you are impugning? What is that? What is the defect you are finding in the order?
Okay.
Or now, instead of order, is settlement. If it is a defective settlement, why you agreed?
Okay. So once it is a settlement, it is
reason should prevail. You signed and say that I have a problem.
Right. I get the
then
point.
Where is the end for that? Then the purpose of the act will be defeated.
Right.
That's not allowed. That's why that is why they have given a first schedule which are not amenable for mediation. Other than not allowed, others are allowed. Then you take as much time you want to settle the matter. There is no deadline. It can be 10 sessions, it can be 2 sessions, it can be 100 sessions. But finally, parties are deciding.
So, sir, suppose they do not arrive at any settlement during that period.
Then it will be, mediator will be reporting no settlements reported. Then it will be judicial.
That period wouldn't be counted for limitation period, sir?
That aspect has not yet come. Once it is, that is why registration with that number, with the authority or a court or a tribunal is important. Then proceedings, that limitation is saved there. But no mediator will go for years together. Hardly 2-3 months.
Without payment also, sir.
Hardly 2-3 months. Yes, Srinivas Garu, welcome.
Good evening, sir.
Good evening, sir.
Sir, while we see this mediation is an invariable choice in terms of matrimonial cases where the courts often refer to mediation.
Yes, family courts.
Yes, sir, family courts.
So the reason is very simple.
The
reason is very simple. Universally, the concept of family, a family, wife, husband, children, okay, and relations here and there. Wife, husband, and children are the miniature unit of the society.
Yes, sir.
Society cannot be stable and peaceful if the family is not stable and peaceful. That's why family courts try every measure, even in the Hindu Marriages Act and divorce, this and that, the last choice. Society cannot run with single parents loitering in the system, even for their own good also. And in a human beings, socially for centuries and millenniums, they live together. Society, families live together. Family means togetherness.
So, sir, my question is further to this, sir. So, where in matrimonial cases or in any such disputes, because a lot of emotions are involved and relationships are coexistence is involved. So, this is invariably, allowed for mediation cases. But
Yes.
in this Section 9 application, where it is purely economical and financial decision.
That's what, there is an inherent contradiction. I told you in the very beginning.
Yes.
I told you in the very beginning, we are converting a non-dispute into a dispute, a claim into a dispute.
Okay.
I supplied material to the CD. There is an invoice.
Hmm.
There is an acknowledgement of debt, and they have not paid. Why should I mediate? It's my legal right.
Correct, sir.
But instead of undergoing the rigors of all these things, and when end will come, we don't know. And I am busy. I want the money should be recycled within my business system. So instead of waiting endlessly for a long time, spending money, ultimately I may or may not get out of the liquidation or out of the CARP process. So considering all this, I'll give a chance to the CD to come and settle in a reasonable way, so that I don't mind closing the matter. So that's why the
Who will
option
bear
is.
the cost?
Pardon?
Who
No,
shall bear the cost of this
No,
mediation?
he will bear the cost. He will bear the cost. Again,
Or the
that
OC
will be
has
further.
to bear.
Actually, the mediator will not charge anything. I have not charged 1 rupee till today in all the 3 matters. And I am not also. Because it is a social service. Because under the NALSA and High Court referred matters. But if it is an arbitration, I charge. Or if it is a NCLT or any other mediation center referred, then they will fix the fees. But money.
Sir, in that case, many would think, why do we do this mediation course? Why do we get certified?
Yes. It is a strain on their
If
time.
it is not remunerative.
It is not for remuneration, first thing.
Okay.
It is a social service.
Social service, okay.
Yes. In fact, in my own office, I conducted 3-4 times the mediation. Okay. And I spent some money on their snacks and tea. Because I always say that we are maintaining peace and harmony in the society. We are instruments in that process. It's a noble profession, no doubt in that. Right. But whether IPs are ready for that, I don't know.
That's what. Because we are looking as one more.
In the coming days, IPPA definitely will fix, and they will charge 1% from us also.
Right now it is 1%, sir. We don't know if we earn from mediation, they might charge 5% now.
But even then, IPPA, if it is coming under IPPA,
IAMC prescribed some fee.
Okay.
Each hour.
IAMC prescribed, because that is
on
not,
hourly basis.
It's not a court. That's why.
Yeah.
Okay. Srinivas, sir, you have raised your hand.
Madam, in IBC, why they are keeping is for admitting a case itself. It is taking 1 year or 1.5 years. To cut short the time delays, mediation helps, madam.
Yes.
So once it is numbered, immediately they can ask for mediation.
It saves court's time and party's time also. Waiting for 1 year.
Like a schedule in the Arbitration Act, where fee is fixed for arbitrator. A day will come in mediation also, depending upon. They may fix some fees, whatever it is, because it's also, we are spending time.
Yes, sir. Otherwise, only 70 plus will be interested to go
it will be a disincentive. No. Commerce matters, no.
Some
reasonable. Some reasonable.
No problem. Just like arbitration schedule, IBC will fix for their own interest.
It will come because they will experiment. It is in experiment stage now.
So, sir, can this happen that suppose if there are more than one Section 9 application against the same CD? Okay, so can all the parties together go for one mediation, or each party has to go to separate mediation?
One more provision is it can be single mediator, or it can be panel of mediators.
Not mediators, sir. I'm asking for the parties itself.
That point I missed out.
Yes,
not necessarily always a single mediator. It can be like a tribunal, arbitration tribunal. 3 members also, 2 members also. The parties can choose.
Okay. Now my question is...
A referring court also. We call it as a court annexed mediation. Court annexed mediation. That court also can fix, depending upon the magnitude of the issue.
Then my question is, suppose there is a single CD against which there are more than one Section 9 application which has been filed. All are yet to be admitted. So in
But
that
numbered,
case,
but numbered,
but
all are
numbered.
numbered, all are
all are
numbered.
numbered. Yes.
Then they should have an association of OCs that.
So I'm asking, is it possible that we have a multi-party mediation, something like that?
Possible, possible.
No.
We have to see. We have to see. But normally, OC, single OC has a power.
Anuradha, it is like this.
Whoever comes first.
No,
See,
that
it
is in
totally
respect of his
voluntary.
claim. See, there may be 10 OCs, but each OC has their own cause of action. There's
Yes, sir.
their own claims. So they are not under any obligation to accept others' settlement with them.
Yes, sir.
Every
Case to case.
this thing is independent.
Case to case. I think you exhausted your question here.
No, sir. Sir, these proceedings.
So per question I should
mediation.
charge.
The mediation settlement.
Per question, 1 lakh per question.
Then for asking the question, I have to charge the audience, sir.
Okay.
Finally, it is for what I'm doing is in REM, sir, not in personam.
Okay.
So, sir, these mediation proceedings are necessarily proceedings in personam, right, sir?
In person, always.
Yes.
In personam.
Always. Because they have removed, in the first schedule, they excluded remedy in REM. I think you remember that.
Yes,
the
sir.
word
Yes,
I used is the REM. The REM word is used in the schedule 1.
Yes, sir.
Okay. In fact, schedule
Sir,
1. Yeah.
Sir,
Schedule
will
1,
the
schedule 1, second matter is that only, last sentence. Declaration having effect of right in REM.
right, sir.
Is not amenable for mediation.
Okay.
Kindly get a copy of the act and go through. It's interesting. Small act.
Yes, sir. I've seen the act. There are 65 sections, 15
yeah.
rules,
I'll
and
share
10
the PPT also with you.
Yeah, sure, sir. And sir, how will the NCLT comprehend that this case is fit for mediation? Or
No,
by
no. Another beautiful point I'd love to say. If
Sir.
OC wants, your lordship, please refer the matter to mediation.
Okay.
Then adjudicating authority has no choice.
Okay.
He can't say
Or
no.
adjudicating authority by a rule, can it say first go for mediation and then come to me?
Yes, they can say.
They can say that.
They can say.
So then where is the voluntariness of the OC, sir?
No. That is, they may say, we don't want to go. An offer will be given. Are you interested? No, they don't pass an order. They say that a suggestion given. Would you like to go for mediation? I think this matter can be mediated instead of litigated. Then the parties say, no, sir, you please adjudicate. Then they have no choice. Okay? It is
Yes,
party-centric. It is party-centric, party-driven.
Yes, sir. Sir,
Madam, what I heard
coming
is
to
IBBI is asking, suggested this mediation is to be mandatory. No option is given to the NCLT.
No, we have to see the regulations.
39 applications.
No.
the regulations are not in place yet.
They have not firmed up.
Yes. They
only
are with
concept
Government of
papers.
India.
Only concept paper in circulation.
Concept paper, it is only it is mandatory.
Let us see how it.
Sir,
how
in
it
the absence of any guidelines, regulations, or how will it go about? So is it? I mean, what is advisable? That do we undergo this training right now, or do we wait for it to?
My friend used to tell, early morning you should be ready after getting your teeth brushed and get ready. Because when the food comes, you are ready to eat.
Okay.
After food comes, you start brushing your teeth. Some dog or cat will eat it.
Okay. Okay. Sir, I'm just taking questions from the chat box.
Yeah.
Sandeep Singh, he says, I am an IP, not a lawyer. Can I become a mediator by completing courses offered by IICA or other education agencies? How the appointment can be done?
He has to contact some 2-3 institutions are there, no?
Yes,
Mr.
sir.
Krishna Mohan referred just now.
Krishna Mohan, sir.
He can contact them.
Okay. Then Kamal Gurnani says, I am an IP ex-banker, not a lawyer. Can I become a mediator? What are the professional opportunities?
Again, same answer.
Okay. Arora sir has already asked this question. Sir, they want the contact number of yours and email ID so that they
Okay,
can get guidance, and PPT needs to be shared, sir.
Okay.
And TVS Shiv Prasad sir has thanked you for excellent presentation.
Thank you.
And Krishnamon sir, thank you for posting this. Okay, sir, question of pre-qualification to become mediator is not replied. Please answer. Kamal Gurmani is
Pre-qualification
asking.
for?
Pre-qualification to become mediator is not replied. Please answer.
You have to check it up. From the websites, they give who are eligible and all that. Even the selection process, in my case, I don't know what process they have followed, but I gave my details. There is a format, and they selected on their own. I don't know what mechanism they followed. I don't know, so I cannot express.
Sure, sir. Anyone else has any other question? Even from IPNet, do we have any questions to ask? Rajiv sir, Namrata, you have anything?
We are good. Rajiv sir, anything?
Not at all.
So Hasni ma'am?
We can't see her on the screen. Okay. So thank you so much, sir.
Thank you very much.
Krishna sir, it was insightful. Thank you so much. So now we have to understand what is Batna, Vatna, and Malatna for us. So
Yes.
whether we do the course now or later,
Yes,
what is most
it's
likely
very
for
interesting.
us?
I'm telling you, mediation is very interesting subject.
Yes,
There are a
sir.
number of books also on this. Authorities are there.
Yes,
But
sir.
it will catch up in the coming days. It is going to stay there.
So not only law, maybe even the professionals have to be stable, but not stand still. So we need to undergo the training program.
Yes, yes. You have to go at the times. Thank you. All the best.
Thank you so much, sir. Thanks a lot, sir.
Thank you for giving this opportunity.
So before
Thank
you
you.
leave, we would just like to offer a certificate of appreciation to our lead speaker for the day, Dr. S.V. Ramakrishna. So Hasni ma'am, can you display it on the screen? Or we will also send it over to your office.
Yes, sir. Yes, Namrata ma'am will send it to sir's office.
And thank you for this wonderful, enriching seminar, and which has opened a lot of prospects on mediation. It's a wonderful course, and it is yet to be notified. A lot of things have yet to be notified, as I understand. But sir, your insights today has helped us a lot, and we really appreciate giving us your time. With this, before I give the vote of thanks, I request Rajiv Agarwal sir to please let us know about the next week's seminar.
Good evening, everyone. I am Rajiv Kumar Agarwal from IPNet East, delegated to invite you to our upcoming webinar on 3rd May 2025 between 4 to 6 p.m. The topic is liquidation under the IBC, challenges, innovations, and the way forward. Esteemed speakers are Ms. Uma Pandey, IPNet member, and Mr. Rajiv Khurana. He is also an IPNet member. Join us for an insightful session where we will explore all practical approach to managing stress effectively during CIRP/liquidation. Stay tuned for registration details. We look forward to your participation. Best regards, IPNet East. Thank you.
Our best wishes to you, sir. All the best for next week's seminar. With this, we come to vote of thanks. It is an honor to extend the vote of thanks for today's webinar. Today's event has been a good learning experience for all of us on the concept of mediation and skill sets of IPs. First and foremost, I extend my heartfelt thanks to our distinguished speaker, Dr. S.V. Ramakrishna, for sharing his profound insights and practical perspectives of mediation skills of IP. Thank you, sir, for sharing your time, wisdom, and experience. Sincere thanks to Anu Bisani, ma'am, for taking out time from her ongoing course for ensuring the success of our webinar today. I would like to express my gratitude to our IPNet president, Mr. Ashish Makhija, sir. Your commitment and visionary leadership has made IPNet an exemplary initiative and a platform of great significance for insolvency professionals pan-India. Thank you for your guiding light for all of us. A special note of appreciation goes to IPNet South team for the successful conduct of this webinar. Your valuable insights in the smooth conduct of webinar has greatly enhanced today's discussion. Another special thanks to the invaluable contribution of Transition and the technical support teams. Their seamless coordination and tireless efforts behind the scenes ensured smooth conduct of webinar. Our gratitude to all participants who have joined us today. Your enthusiasm, active engagement, and thought-provoking contributions have truly made this very, very, very special. Thank you so much once again. Krishna sir, thank you so much.